Good morning. Good morning, Instagram. Good morning, Facebook. And good morning, YouTube. I'm just going to wait for you guys to tune in. Good morning. Come on in. If this is your first time, welcome. Let us know where you are tuning in from. Stevie Breezy, good morning. Thank you for joining. If this is your first time, definitely, comment in there so I can give you a shout out. Hello, Awura, Ama, and Stretch Mullet. Good morning, Olivia and Campbell on YouTube. Good morning. Um, okay. And just start putting your questions in. I'll try and answer as many questions as I can today. If you're joining for the first time, let me introduce myself. My name is Aisha Chidole, and I'm an immigration lawyer. I represent clients all over the United States with their immigration matters. We deal with family-based immigration as well as humanitarian-based trafficking and victims of serious crime cases. We also handle waivers, complex noise, RFEs, and all those other things. If you would like to schedule a consultation, you can call us 407-995-6567. You can also call 678-325-1037. And then if you want to send a WhatsApp for us to call you, then you can write 404-333-8751. That's our WhatsApp number. Okay, let's just jump right into it. I see someone is asking, my wife is asking for a divorce a few weeks before our interview. What should my plan B be? Well, at the end of the day, if you don't have a good faith marriage or you don't have a marriage that is continuing or existing, you want to definitely speak to an attorney to see if you're eligible for anything else, because I'm assuming that if your wife is asking for a divorce, then she's not planning to show up for your interview, or she's planning to show up for your interview and sabotage it. So I would definitely recommend that you speak with a lawyer and just consult and let them screen you and understand like the history of your relationship and see if you're eligible for, abuse, extreme cruelty. If you are, then you can probably do like convert your application if you are eligible. And if you want to schedule a call with us, our number is, in our profile. It's scrolling through the ticker on Facebook and YouTube as well. Is there a delay in receiving the receipt notice from USCIS upon submitted new application? This is a good question, and the answer is going to depend on what kind of application that you submitted. If you're submitting any application where there are filing fees, we're not seeing delays in those. Those we're seeing definitely anywhere from like 3 to 5 weeks, tops 6 weeks from when we get receipts. If you're submitting a case where there are no filing receipts, like humanitarian cases, like VAWA cases, trafficking, like T visa cases, or U visas, we're definitely seeing like up to 90 days, 100 days even for receipts for those types of cases. I will say that as of late last month, I think September 18th will be the last date. And this is something for you guys to know, especially those of you that are trying to do this by yourself. The locations in which you can file VAWAs and work permits related to your filing and all of that has changed. So it's very, very important that you're looking at your state and what it says as far as where to file. In the past, everything would have been sent to Nebraska, Lincoln, Nebraska, but that has changed. And I say this to say, I am hoping that with the expansion of adding this new, PO box locations, well, they call them lock boxes, that the goal is that they're going to process it quicker, because these cases, T cases, U cases, VAWA cases were being sent to one location. So I think that this is me thinking, we'll see once they completely ban sending it to Nebraska only. I'm thinking that because now they've added like several new locations to submit depending on where you live, that it will make some of those receipt notices come quicker. But I'll keep you updated if I notice a trend there. One trend though that I have noticed, and I definitely want to share that with you guys, to also give you hope, is that we're seeing that Family-based cases and marriage-based cases that are being filed this year, post-January, they are moving very, very fast. Very, 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 very fast. So meaning they're getting their interviews, they're getting their approval. I'm only speaking about my clients. I can't speak about anybody else very quickly. So, I know that there's some people that are like, oh, should I file now? If you are eligible for something, why shouldn't you file, right? If you know you're eligible for something, you should immediately want to gain your legal status so that you are not, living in fear or living in the shadows, wondering on every single day what's going to happen to me today. So if you are eligible for something, especially a marriage-based case or a family-based case, like, parent of a U.S. citizen, child of a U.S. citizen, all those types of things, where you can adjust your status, you should file, because right now those cases are being processed very quickly, in months, like some 3 months, 4 months, 5 months, 6 months, 7 months. Like, we're seeing cases where they're going to the interviews, they've not yet gotten their work permit or travel permit, and they're coming out with an approval. And if you don't believe me, you can check my page, right? Because sometimes when I put the results, you can see the date that was received versus the date they were approved. Okay. So I hope that answers your question. Okay. I've been, this is from Make Mapasa. I've been outside the USA since January. Will I have a tough time coming back? I have a green card and I left because my husband is deployed overseas. As long as you're showing that you have not abandoned your your U.S. residency. So you might be called into secondary, but I think that you have a legitimate reason where you were deployed. I would recommend that you don't stay for more than a year without coming back into the country, because you would have abandoned your green card. So you want to come back in. I mean, of course, this is going to reduce the timeline, or increase the timeline, I should say, of which you become eligible to file for citizenship. But when you're coming in, you want to make sure that you have that documentation of your husband's deployment. And, obviously with US wanting to keep families together, it's very understandable that you would want to travel, stay with your husband, or your, did you say your husband? Yeah, stay with your husband who is serving the United States, in another country, okay? Sunison, good morning. Aurora from Columbus, good morning. Dr. Angie in Atlanta, good morning. Stretch Miller says, where are you? I'm in Atlanta, Georgia. Good morning and welcome. Philly in the house, good morning. Okay, let's see what other questions we have here. Okay, answer this one. What do you expect? I can't understand this question. Let me see if I can change the question or understand a little better. You said, when do you expect an RFU valid through I-360 and Billy Bangor? Like, maybe you can ask that question again. I'm not sure I understand what you're asking me. Someone says, can you use a green card extension letter to travel? So the answer is that it depends. So when you file for an I-751 application, which is an application to remove the conditions on your 2-year green card, normally USCIS is going to give you a 48-month extension regardless of when you filed it. So the key thing is going to be, the key question you have to ask yourself is this: did you file it on time? If you filed it on time and your 4-year window is still, has not expired, then you now want to look at, do you have any criminal records? Do you have anything, in your history, your immigration history, that can make you questionable, subject you to any kind of interrogation that's not going to be pleasant? If all the answer to that is no, then feel free to travel. Now, there are going to be some people that file their I-751 late. And for those people, those will be people who maybe they're filing it because their spouse refused to do a joint filing with them. So they filed, based on extreme hardship, or they filed based on, divorce, or they filed based on extreme cruelty and abuse. Because with those, there's no set timeline. You can file late. I've even had someone file as late as 12 years, who we got the green card, and right now I'm just working on naturalization for that person, as a matter of fact. But there are people that file late, So if you file late, the key thing you have to pay attention to when you get those extensions is you want to count from the date of expiration on the actual green card. Every time you get an I-751 extension letter, you count from the date of expiration on the actual green card. I will give you an example of where it can be tricky. For instance, if your 2-year green card expired in 2019 and you didn't know that you didn't have to file with your husband, and now you found out that you can do a waiver, for example, right? You can then file. Let's say you file now and you get a receipt. The receipt is going to say 48 months, but it doesn't mean 48 months from the date that you got the receipt. It means 48 months, basically 4 years from when it expired in 2019. So technically, that would have expired in 2023. Now, the question is, how do you extend it to allow you to continue to remain in status or to continue to be able to travel? At that time, you can schedule an info pass at the local USCIS office near you and bring your receipt notice, and they will give you what we call an ADIT stamp, ADIT stamp. That stamp is your I-551, and I-551 is basically your green card. So that stamp basically will now extend your green card for 1 additional year from the date in which you bring it over for the ADIT stamp. So if you go to the ADIT stamp, go to the info pass today, then they will extend it from today's September 16th, from September 16, 2025 to September 16, 2026, while your case is pending. When it almost expires, if they've not made a decision in your case, then you go get another ADIT stamp. So it's very, very important because a lot of times people don't know where to count that 48 months. So that's where you're counting from, okay? And as long as you've counted it correctly and as long as you have that extension, yes, you can travel. But again, I say this without knowing anything about you in particular. Something I always tell my clients, before you travel, it's always important to reach out to your lawyer because we need to know what stage are we in your case. What kind of case do you have? Do we have an RFE? Do we have a NOID? Are we expecting an interview anytime soon? Because we have to make decisions, especially right now, with so much, there's just so many moving parts that we just don't want to take for granted or gamble on, well, I'm going to be good. Yes, can you go and be fine? Absolutely. But do you want to make sure you are being diligent and making sure that you're crossing all your T's and dotting all your I's? Yes, you should definitely be doing that. Okay. Amaka says, good morning, Aisha. My valid is 43 months plus 6 prima facies, no RFEs. My most recent prima facie expired 2 weeks ago. So do you think I might be getting a decision soon? I do think you'll be getting a decision soon. And I think also this is also a good time to reach out to USCIS to basically find out if there's something that they need from you to make a decision. So if they've not made a decision and they need to request additional evidence, let them request the evidence so that you can at least work on that so you can move forward with your case. But at this time, I would say this is a good time to reach out. What is it that they say? Closed mouths don't get fed, right? So 43 months is definitely on the upper side. So definitely, and especially because you said you didn't have any RFEs or anything like that, this is a good time. So either a decision or give me a request for evidence. Give us one thing. Let's just know where we're going. Okay? All right, let's see what else we got here. Do I have to give her a ring, my future wife, first before filing for a K1 visa? So a ring is not something that is synonymous to every culture. So there are many cultures that don't give rings. As long as you and your spouse have an understanding that you are engaged to be married. In some cultures, like for instance, let me use Nigeria, because giving a ring is a Western culture. It's a Western culture. Now, do countries imbibe and start, taking on things from the West? Absolutely. But traditionally, if you're, using Nigeria, for example, I'm going to use myself, I'm Igbo, my husband is Igbo. Granted, he did it the Western way, but an engagement as far as our family is concerned is when you go knock on the door and tell the other family, listen, I'm trying to marry your daughter or whatever the case may be. and they plan, the wine carrying or whatever it is, and you get engaged, right? So before the traditional marriage, they call it ikwaka. I'm sure those of you that are Igbo here know what I'm talking about. But so it just depends on the culture. As long as your future spouse understands that you're engaged, so a ring is not what determines whether you're engaged. It's the action, right? Did you tell her that you want to marry her? Did she tell you she wants to marry you? Did you agree to that? If you agree to that, then you're engaged. Okay. If your undocumented beneficiary spouse, if you do an I-130, will he get an NTA? Not a criminal. What happens if he gets an NTA now that there's no bond? So I am going to assume when you say undocumented here, you're specifically saying that you crossed the border, so there's no documentation of your entry into the United States, correct? Yes. If that is correct, here's what I'm going to say. Personally, I would not file an I-130 right now. In the past, you would file an I-130 if you don't have any criminal records, you're law-abiding. And then once that I-130 is approved, then you will apply for a hardship waiver, a 601A waiver, basically saying that you're sure that if they don't allow you to stay here, it's going to be hardships to your U.S. citizen spouse, or your U.S. citizen, or your green card holder spouse, or your green card holder parent, or your U.S. citizen parent, right? And if that is approved, then you must go back to your home country. So that's something that a lot of people don't understand. Like when I read comments and they think that there's actually, you're just going to become you can just come in here and get it. No, like the law actually, in all administrations, the law actually states that if you enter that way, in order to file a family petition or a marriage-based petition, you have to get that waiver and you have to go back, and do your interview back and do it the right way, right? So that's the normal way that it's done. But right now, because of how they entered, you can be subject to an NTA, right? And an NTA means, for those of you who don't know, a notice to appear in front of an immigration judge or deportation judge. And, so I have colleagues who have done this and they approved them for the I-130, but they gave an NTA to the client. So it's going to depend on if USCIS, or since they now have arresting powers, decides that they want to detain you or they don't want to detain you, right? So if they detain you and you don't have any documentation of how you entered here, you don't have any bond. So you're going to be in there for however long, until you can go through the process. So that's something you really want to consider. The answer basically is that I would not, and I wouldn't advise someone who comes to me to do it because of right now, unless something changes in the rule. Right now, you have to be prepared for that, as one of the worst case scenarios, which is likely. It's not like a low chance, it's a high chance. Now, let's say, in what situations or in what circumstances can an undocumented person apply if they're eligible for something that is legal? Now, if you are a victim of VAWA and you're married to a U.S. citizen, what is VAWA? Being a victim of abuse, extreme cruelty, but you must be legally married. You must have a qualifying marriage. You must be married to a U.S. citizen or a green card holder. You must have lived with that person either before marriage or at some point during marriage. You must be a person of good moral character, so you don't have crimes of moral turpitude or certain crimes that make you ineligible, and they must have been abused. Like if you have those, then you can actually file and be safe, right? You can file and get your green card here without having to leave the country. The same would apply in being a victim of labor trafficking, sex trafficking, commercial sex trafficking, human trafficking. If you find yourself basically you're here, on account of someone who has, either coerced you, enticed you to come here under fraudulent pretenses, or you came here but were kept here, and even if you wanted to leave, you were basically in bondage or debt bondage to someone saying, well, I brought you here, you're going to have to keep paying me until you can escape, or, you're going to have to be here and be my sex slave, or you must stay here and do this job. I'm not going to pay you a living wage and deal with it. If not, I'm going to report to immigration. If you qualify for something like that, we call that a T visa, then you can apply in those situations, and understanding that in that situation you typically will be working with law enforcement or the FBI or your state's FBI, or Department of Labor to basically investigate the case. In those cases, it's okay to apply. Same thing with the U visa. U visa is basically being a victim of a serious crime, and you have some kind of law enforcement certification showing that you cooperated with law enforcement regarding that crime. Now, I can't go through the list of all the crimes right now, but the key is, there must have been some sort of law enforcement, cooperation, to be eligible for you. You can't just say, I was a victim of a crime, but I told them nothing happened, because then they can't certify, like that has to be certified. So those would be the circumstances in which someone who came here undocumented, and when I say undocumented, I specifically mean people who there's no record of them entering into the country, meaning they didn't come with any kind of visa. They came basically through a border of some sort, okay? Okay, someone is asking, hello, Queen of Vala, can someone travel now that they got their permanent resident green card? She doesn't have any criminal records. The only thing is she overstayed her visa because her country was on lockdown for COVID. You're absolutely fine to travel as long as you have your green card and you don't have any criminal record. Congratulations and enjoy your trip. If someone gets a work permit and a travel permit from VAWA, and for the I-485, the case is transferred for jurisdiction, what does that mean? It just depends. It depends on what stage you are in your case. Sometimes if you filed in Nebraska and Vermont is making a decision, it means that they've transferred the case to Vermont, right, for Vermont to make the decision. If it's after you've gotten your VAWA approved, then they're transferring it to your local field office for them to decide if they're going to either schedule you for an interview or waive an interview. Right now, for VAWA cases that are approved, I would say that we're seeing about 50-50. Some get called for an interview, and the other 50, they will just go ahead and approve you for your green card, okay? Rita says, can someone with a pending VAWA case marry again with someone else? No, if you want your VAWA case to be approved. So nobody's holding a gun to your head and saying that you cannot marry. But if you have a pending VAWA, you become ineligible for VAWA the minute you get married. You have to wait until they make a decision on your I-360. Otherwise, you become disqualified from filing for VAWA, okay? Okay. My mom has been here since 2017 and is a permanent resident. She wants to do her citizenship interview but doesn't speak English. She's 70 years old. Please, what should be done in her case? She's not going to be able to get it. She needs to learn English, or at least learn enough to be able to answer the civics question, to be able to write in English, a sentence in English, and read a sentence in English. Typically, because she's just not had a green card long enough for her to be exempt from the English requirement. Usually it's like, it goes from 15, 20, 25 years. I always mix up the numbers, so I always have to pull it up to confirm. So I can't give you the exact, but the age part she meets, but she doesn't meet the part where she has to have had her green card for a certain amount of time. So she can either wait for a couple more years until she's had a green card for a couple more years, and she can be exempt from the English portion of the exam. Okay. All right, let's see what else we have. Someone says, out of context, you look good and pretty nails. Thank you so much. My nails are actually horrible. As you can see, I have like 2 nails that are not done because I'm so busy working. And when I'm not working, I'm so busy with my own kids who are very busy, as teenagers. Like sometimes I don't even have time for self-care, but it's whatever. I filed an I-765, adjustment of status at VAWA. I received all my receipts from Fasci Biometrics. How long will it take for me to get my EAD? Typically, you can expect your EAD anywhere from like 4 to 10 months from submission. So hopefully you get it within that window. I'd say most people get it around like 6.5 months, 6.5 months-ish. Did I answer this question already? Yes, I answered this question already about the deployment. Can I upload more evidence on USCIS website for my submitted I-130? We have our baby's birth certificate and photos and two notarized affidavits. Is that enough? Absolutely. You can absolutely upload more evidence. If you can, that's great. And then also you can bring them with you to your interview as well. Someone is asking about how long it takes to receive, about work permits. I just answered that question. How soon after I receive a prima facie determination letter should I look out for work authorization? Again, guys, it's the same thing. Like I said, prima facies don't determine whether or not you're going to get a work permit. Prima facies determine whether or not they should continue processing your case and requesting evidence. Work permits will typically come anywhere between like 4 to 10 months from submission. Do you have a consultation fee? Yes, it's $150. So feel free to call us to schedule. Effie Dexter says, no one seems to be responding to my messages on my case platform. Send me an email with your full name and then I'll look into that. Okay. I see a lot of the questions are about work permits, so I'm not going to answer them anymore since the answer is the same. My conditional removal has just been denied. No right to appeal. What are my options, Ma? That is actually terrible. Removal of conditions being denied is not good. It means that you will get a notice to appear in front of an immigration judge for deportation. Depending on what you would have selected in your I-751, you will only be able to plead whatever you wrote on there at the NTA. Your only other option is to try and file ASAP, refile ASAP with stronger evidence, or see if you qualify for one of the waivers like extreme hardship, divorce, abuse, or I don't know if your spouse is living or late, and file it, because then when you file it, the USCIS has jurisdiction, and typically what will happen is that the judge will put the case on hold to allow them to adjudicate in your filing. But basically with the I-751s, every single thing that you're eligible for in the form, you want to select everything that you're eligible for, so that if they say, you know what, we don't think there's enough, this case is not strong enough for abuse, whatever it is, but let's say there's divorce and there's good faith marriage, then they can approve you on that. Let's say there's good faith marriage or an extreme hardship, then they can approve you for that. So you can refile, but fully expect that whether you're refiling or not, you will be getting a notice to appear in front of an immigration judge. That is a requirement for conditional green cards that file I-751s that get denied. And that's why I'm harping on this a lot, because we're seeing a lot of people coming to us who had interview waivers, meaning like they didn't get the interviews. They weren't scheduled for interviews when they got their 2-year green card. So a lot of them really didn't know like they should be keeping documentation and things to show that you've continued your marriage is legitimate, you have a good faith marriage. And now like a lot of them are like, oh my gosh, I don't have anything, I'm no longer with my spouse, I'm having issues with my spouse, so the removal of conditions, again, I don't like to scare you guys, but I have to give you the reality. These applications are very serious, very, very serious. Like, you will get put in deportation if your removal case gets denied. Like, there's no questions about it. Okay. Let's see. All right, guys, I actually have to jump off. But it was nice chatting with you all. If you have any other questions or you would like to schedule a consultation, call us 407-995-6567, or you can also send a WhatsApp message to 404-333-8751. And all our contact is on our profile on every platform that you're on. I hope you guys have an amazing day, and I will talk to you guys later. Bye.